The first stage of the appeal begins with a notice, essentially a letter, informing you of an upcoming mediation conference. This conference is an informal meeting of the parties chaired by a mediation judge from the BIIA. The conference could take place by phone or face-to-face. The notice will tell you the date and time of your conference and whether you'll need to appear in person or by telephone. In either case, you'll be able to explain your side of the story to the mediation judge in a more relaxed setting than a formal hearing. You'll need to have the following items for your conference: a copy of the jurisdictional history of your case to show that the BIIA has authority to hear the appeal. These are yellow sheets sent with the letter granting your appeal. Your calendar to schedule future conferences if necessary. Medical records or other documents that support your case.
This is the mediation conference for Kate Jones. You're Ms. Jones?
I am.
The main purpose of the mediation conference is to try to settle the appeal without the complexities of a formal hearing.
Industries.
That is correct, Your Honor. I'm Robert Smith. Ms. Jones, how do you do?
Pleased to meet you.
Glad to meet you.
A settlement in mediation is the least costly way to resolve an appeal.
A few things with you, Ms. Jones, about what we can accomplish and what we can't accomplish in a mediation conference.
The role of the mediation judge is to assist the parties in reaching a resolution that's acceptable to all. With this more casual process, the mediation judge will want to know what it is that you want from the appeal. Be prepared to describe your desired outcome or relief.
What I would like to know is what you want from this appeal, and that is, are you interested in having an increased permanent partial disability award, or are you interested in more treatment or time loss compensation? What is it that you actually want?
Well, my arm still hurts pretty badly, and so I'm wondering whether I need some more treatment. You know, I haven't been able to see the doctor because the department closed the claim, and so they won't let me go back to the doctor and pay for it.
Well, have you been to the doctor at all since the claim was closed?
No.
The judge will listen to the worker, the employer, the L&I representative, and possibly attorneys for the parties. You do not need an attorney for this informal process. If you do hire an attorney, he or she will notify the BIIA and receive notices of all proceedings. Remember, this is not a formal hearing. Witnesses will not be called to testify. The mediation judge will review L&I's claim file and any information that the parties present. The judge will look at your evidence supporting the requested relief and possibly suggest additional kinds of support you will need to win your appeal. The judge will go over information on previous cases and relevant BIIA or appellate decisions to determine if an appeal might be successful. A record will be made only of the results of the conference. Information gathered in the conference is confidential and will not be used in the hearing process if the appeal should progress to the next level.
Well, as a mediator, one of the first things I try to do is set a tone with the parties that this is going to be an informal, helpful discussion about the appeal. After that, I try to get some information from the person who's filed the appeal, and if it's the claimant, the injured worker, I want to know what they want. What are they trying to accomplish by having filed the appeal?
Mediation is an informal environment, and so it's not like a court of law or a courtroom that can be very intimidating. They can actually sit down, discuss the issue openly, and look for ways to settle it. The mediation judges are very good in kind of guiding parties in that discussion. It's not a hostile environment, it's not an uncomfortable environment, it's an environment where they can talk openly and frankly in an attempt to resolve the issue.
If the parties can reach a settlement that is supported by law, with facts agreed to by all of the parties, then the board will issue what is called an Order on Agreement of Parties. With this order, the board explains the terms of the settlement and directs the Department of Labor and Industries to take the agreed action on the claim. If the parties cannot reach a settlement in the mediation conference, the dispute will move to the more formal hearing stage.